In November 1999, a federal judge in Washington, D.C. made a finding of fact that read like an indictment. Microsoft Corporation, he concluded, had used its monopoly power to crush competitors, intimidate partners, and deceive the court. Within 6 months, he would order the company cut in half. The stock would lose $80 billion in value, and then almost nothing would happen. This is the story of how the most expensive antitrust case in American history ended without breaking up the defendant. Where did the money actually go? To understand what the government was accusing Microsoft of, you have to understand what Microsoft actually was in 1998. Not a software company in the way we use that phrase today, a casual thing ambient everywhere. Microsoft in 1998 was infrastructure. Windows ran on roughly 90% of the world's personal computers. If you wanted to sell software, you needed Windows to run it. If you needed Windows to run it, you needed Microsoft's permission, or at least its cooperation. That is not a metaphor, it is a market structure. And market structures like that have a name in American law, a monopoly. The Department of Justice, joined by 20 state attorneys general, filed suit in May 1998. The central accusation was not simply that Microsoft was dominant. Dominance is not illegal. The accusation was that Microsoft had used that dominance as a weapon, specifically against Netscape Navigator, the web browser that by the mid-90s had become the most popular on-ramp to the early internet. The government's theory was elegant and alarming. Microsoft had looked at Netscape, understood that a powerful browser could eventually make the underlying operating system irrelevant, and decided to destroy it. Not compete with it, destroy it. The internal evidence the government assembled was extraordinary. Emails, actual emails, printed and entered into the trial record, showed Microsoft executives describing Netscape in terms that had nothing to do with product quality. One email, written by a senior executive, described a meeting with Netscape in 1995 in which Microsoft reportedly proposed dividing the browser market. Netscape could have certain platforms, Microsoft would have others. Netscape refused. What followed, the government argued, was methodical. Microsoft built its own browser, Internet Explorer, and did something that seemed almost irrational from a pure business standpoint. It gave it away for free, not as a promotion, permanently free. Netscape charged for its browser. Microsoft could absorb the loss indefinitely. Netscape could not, but the government's sharpest argument was not about pricing, it was about access. Microsoft began requiring computer manufacturers, the companies that actually put machines in people's homes, to install Internet Explorer as a condition of their Windows license. If you wanted Windows, you took the browser. If you took the browser, your customers saw it first. Netscape's distribution was strangled before a single line of competing code was ever written. The trial began in October 1998 in the courtroom of Judge Thomas Penfield Jackson. Jackson was 62, a Ronald Reagan appointee, and by all accounts a careful jurist. What unfolded in his courtroom over the next few months was a collision of two entirely different realities. The government presented its emails, its economic analysis, its parade of witnesses, including executives from companies that testified Microsoft had threatened them, pressured them, cut off their oxygen. The defense presented Bill Gates, or tried to. Gates had given a video deposition before trial that became one of the most discussed pieces of legal footage of the decade, not because it was incriminating in any single moment, but because of its cumulative texture. Gates repeatedly said he could not recall. He parsed words in ways that struck observers as evasive. When shown emails he had written, he sometimes disputed what they meant. Prosecutors played clips of the deposition in court, and by contemporary press accounts, courtroom observers laughed out loud. That is not a characterization. It was reported across multiple news organizations at the time. The defense's expert witnesses fared no better. One had his economic models publicly dismantled by the government's cross-examination. Another's testimony was later described by the judge himself as, quote, at times frivolous. Jackson was watching all of this. He was forming a view. On November 5, 1999, Judge Jackson issued his findings of fact, 107 pages. In federal antitrust cases, the findings of fact and the legal conclusions are issued separately. This was the facts, and the facts, as Jackson found them, were brutal. Microsoft possessed monopoly power in the market for personal computer operating systems. Microsoft had maintained that power through anti-competitive means. Microsoft had harmed consumers. He found that the company had engaged in, quote, predatory behavior. He found that its actions had set back innovation. He found that its executives had not been credible witnesses. The stock market did not wait for the legal conclusions. Microsoft shares, which had peaked at just over $60 in late 1999, began to slide. Investors understood what the findings meant. The conclusions would follow, and the conclusions would come with remedies. The question was not whether Microsoft had lost. The question was what losing would cost. The answer, when it came in April 2000, was existential. Judge Jackson ordered Microsoft to be broken into two separate companies. One company would sell Windows, the other would sell everything else: Office, Internet Explorer, all the applications. The theory was sound. If the companies were separate, the applications company would have every incentive to write software for competing operating systems. The stranglehold on the market would loosen over time. Between January and December of 2000, Microsoft lost roughly $80 billion in market capitalization. To be precise about what that number means, it is the total value the market assigned to the company, multiplied across every share outstanding, and it fell by that amount over the course of that year. Some of that decline was the broader collapse of technology stocks in the dot-com bust. The Nasdaq fell nearly 40% in 2000. But Microsoft fell harder than the index, and it fell earlier. The breakup order was a significant part of that. Now, here's where the story turns. Jackson had made a procedural error, or perhaps more than one. While the case was still active, he had given extensive interviews to journalists in which he compared Microsoft's executives to drug dealers and street gangs, not as an anonymous source, on the record while the case was pending before him. The D.C. Circuit Court of Appeals found this conduct disqualifying. In June 2001, the appeals court did something unusual. It upheld the finding that Microsoft was a monopoly, which was the hard legal work of the case. But it threw out the breakup order. It removed Jackson from the case, and it sent the remedy phase to a new judge with instructions to reconsider what punishment, if any, was appropriate. Microsoft had not been vindicated, but it had been saved. The Bush administration had taken office in January 2001. The Clinton-era DOJ had driven the case. The incoming team had different instincts. In September 2001, 9 days after the September 11th attacks, which compressed the news cycle in ways that some observers noted were convenient, the Department of Justice announced it would no longer seek to break up Microsoft. It would settle. The settlement, finalized in November 2001 and approved by the court in 2004, after years of objections from the states, required Microsoft to share its application programming interfaces with third parties. It required the company to allow computer manufacturers to feature competing software more prominently. It established a technical committee with access to Microsoft systems, records, and source code to monitor compliance. 9 states refused to join the federal settlement, believing it was too weak, and pursued their own remedies, eventually also settling for slightly different terms. Critics called the federal settlement a gift. Supporters called it pragmatic. The empirical debate continues among economists and antitrust scholars to this day, and that is not a caveat, it is the honest state of the record. What is not in dispute is this: Microsoft was not broken up. Its core business structure remained intact, and within a few years, its stock had largely recovered. So where did the money actually go? Let's follow it. Microsoft's legal fees for the antitrust defense are not fully public, but estimates from legal industry analysts at the time put the total between $500 million and $1 billion across the full trial and remedies phase. The company also dramatically expanded its Washington lobbying operation during this period. In 1995, Microsoft spent virtually nothing on federal lobbying. It was famously absent from that world. By 2000, it was spending millions annually and had established a dedicated government affairs office in the Capitol. That is documented in federal lobbying disclosures. The $80 billion in lost market capitalization did not go anywhere in the conventional sense. It was value that existed on paper and then ceased to exist on paper. Shareholders who sold during the decline realized actual losses. Shareholders who held recovered most of it by the mid-2000s. The states that litigated separately collected some monetary damages. California, for instance, extracted a settlement that funded technology donations to schools. That money moved. The lawyers on both sides were paid. The economists who testified were paid. The expert witnesses, the compliance monitors, the technical committee paid. The government's litigation costs were absorbed by the public, and Netscape, by the time the case concluded, it was effectively over as a competitive force. AOL had acquired it in 1999. It would be discontinued as a product by 2008. The browser war Microsoft was accused of winning. It had already won it. The trial documented a victory that the market had already recorded. The case did not break up Microsoft, but the question of whether it changed anything is more complicated than that. Several antitrust scholars have argued, and this is the mainstream view in the academic literature, that the case created a chilling effect on Microsoft's competitive behavior during a critical window. In the early 2000s, as Google was being built, as Firefox was being developed, as a new generation of internet companies were growing, Microsoft was operating under a consent decree and the scrutiny that came with it. Whether that restraint created the space for those companies to survive their early years is genuinely debated. It cannot be proven, but it is a serious argument made by serious people, and it belongs in any honest accounting of what the case accomplished. What is not debated, the case produced the most detailed public record ever assembled about how a technology monopoly operates, how it prices, how it negotiates, how it communicates internally when it believes no one is watching. That record became a textbook. When the European Commission took on Microsoft in the years that followed, it used that record. When regulators in later decades began examining the next generation of technology companies, the legal frameworks, the economic theories, the evidentiary standards, all of it had been sharpened on United States v. Microsoft. The case failed to achieve its stated remedy. It may have achieved something more durable, a language for talking about technology and power that didn't exist before. The money that evaporated came back, the precedent stayed. Here is the question I keep returning to, and I think it's worth leaving with you. If the judge had kept his conduct above reproach and the breakup had actually happened, would the technology industry look the way it does today, or would some version of it look exactly the same?